Hilary Charlesworth is one of the most innovative international lawyers and original voices in the field of international law in the last generation. I express my deep admiration for Justice Charlesworth's remarkable contributions to the legal landscape, particularly in her involvement as an ad hoc judge in the ICJ. In pivotal cases such as Guyana versus Venezuela, which centered on an arbitral award, and the notable whaling case Australia versus Japan. Justice Charsworth's contribution in the field of international law have also earned her widespread acclaim. Her erudition and expertise have illuminated countless legal debates and enriched the global discourse on matters of utmost significance. As one of the select few women to be elected as a permanent judge in the ICJ's 78-year-old history, the presence of Justice Charsworth in the International Court of Justice heralds a new era characterized by inclusivity and diversity. Furthermore, Justice Charsworth has admirably assumed the role of a great mentor to numerous aspiring professionals and scholars within the sphere of international law, notably prioritizing support for women. Her dedication to fostering the next generation of lawyers and advocates for equal treatment in the courts is inspiring. Our audience will be delighted to know that our own Chief Justice of India, Dr. D.Y. Chandrachud, and Justice Saraswat pursued their doctorate degrees in the same years at the Harvard Law School. It's a pleasure to have these two internationally renowned jurists grace this task together. This year, on the 28th of January, the Supreme Court of India marked the beginning of its Diamond Jubilee year and stands poised at the threshold of a new age characterized by heightened collaborations with judicial counterparts at not only disseminating our cherished values but also encouraging a meaningful exchange of best practices by engaging in fruitful dialogue and forging long-term partnerships. The Supreme Court of India endeavors to nurture a shared understanding while embracing the unique perspective that embellish our collective pursuit of justice. The commitment of Supreme Court of India to prioritize the rule of law and value the significance of human rights needs no emphasis. The Apex Court has consistently demonstrated a nuanced understanding of global progress in the human rights discourse and legal frameworks, and has not only upheld the tenets of the Indian Constitution but also enhanced the broader international conversation on justice and rights. These judicial pronouncements resonate universally, impacting judicial doctrines and acknowledging emerging rights across jurisdictions. Today's lecture marks the continuation of Supreme Court of India's steadfast determination to initiating global dialogues on justice. Through the invitation extended to distinguished jurists from around the world, we aspire to facilitate open and candid discussions on various issues confronting our justice systems. We are eagerly anticipating Justice Charlesworth's illuminating insights as he delves into the topic, the International Court of Justice, a legal forum in a political environment. As we know, the International Court of Justice, being the principal judicial autonomous organ of the United Nations, is a promising platform for the nation states to seek redress and uphold the rule of law on the global stage. The International Court faces unique challenges in upholding its judicial independence and impartiality in the constantly evolving political arena. How this court manages to sail through troubled waters is quite interesting. The words of wisdom of Justice Charsworth will surely make us understand how they untangle the inner knots of these intricacies. With her extensive experience as a judge of ICJ and her proficiency in international law, both as an academic scholar and a jurist, we look forward to gleaning invaluable overview that will undoubtedly enhance our understanding and refine our thoughts on this pertinent subject matter. With these few words, I once again thanks and convey a very welcome to each and every one of you to this great event. Thank you very much.
Thank you, sir. I would now like to call upon Dr. Justice D.Y. Chandrachud, Chief Justice of India, to kindly share his thoughts with us.
A very distinguished guest and speaker for today, Justice Hilary Charlesworth, Judge of the International Court of Justice, my colleagues, judges of the Supreme Court of India, former Chief Justices of India, former judges of the Supreme Court of India who enhanced the dignity of this function by gracing this occasion, Chief Justices of the High Courts, the Attorney General for India, the Solicitor General of India, Mr. Venkatramani and Mr. Tushar Mehta, respectively, President and Secretary of the Supreme Court Bar Association and of the Supreme Court's Advocates on Record Association, Senior Counsel. I was just telling Justice Charlesworth that we have more women senior advocates who've been designated in one law than we had over 75 years of our history. Distinguished guests, members of the bar, and all the invitees here. First and foremost, I must share a little secret with the over 600 plus audience that we have this morning. Thank you, all of you, for joining us. But the secret I want to share with you is that we have a birthday boy in our midst. Happy birthday to Justice Surya Kant. It is indeed a moment of honor for me to join Brother Justice Surya Kant and all of you in welcoming to the Supreme Court Justice Hilary Charlesworth, a judge of the International Court of Justice, an esteemed scholar, a pioneering feminist thinker, and most importantly, a dear old friend. Now, I have in my text of the speech put old into inverted commas for the simple reason that what I say about Hillary in time. And I forged a strong and enduring bond and pursued our doctoral studies leading up to the SJD together. We both completed our Doctor of Juridical Science in 1986. We discovered common interests and values that solidified our friendship. We attended classes and seminars together, engaging in meaningful conversations about law and philosophy. Our friendship extended beyond the classroom as we spent our formative years discovering Cambridge. Harvard Law School's academic rigor posed a formidable challenge, yet our friendship provided invaluable support, easing the journey as we navigated through the demanding curriculum. On a lighter vein, there's a quote by Charles Morgan, a British playwright, that I often think about when I look back at my days at Harvard Law School. And Charles Morgan said, if Moses had gone to Harvard Law School and spent years working on the Hill, he would have written the Ten Commandments with three exceptions and a savings clause. In a movie which is based on Harvard, which is very close to my heart, I've watched it several times, called The Paper Chase. The last scene of The Paper Chase is when these graduating students at Harvard Law School make paper rockets out of their marks sheets, the degree certificates, and then let them into the wind to flow into the breeze. I think I never realized the importance of that until I was reflecting on it again this morning. And I believe what it really tells us is that in this great equalizer of life and the profession, our birthmarks are surely, but surely erased, at least over time. Hilary attended, like me, Lawrence Tribe's course in constitutional law, and she was the only person in the class who got an A plus from Lawrence Tribe. So I became a supervisor for the SJD. As students of the SJD program, we had the best perquisite available on display at Harvard, which was we had offices of our own, all overlooking the beautiful greens. We also played our own version of the Davis Cup together at Harvard Law School. We had, as Hilary always said, a team comprising of players from Australia, India, Ethiopia, and New Zealand. But the standout image that remains etched in my memory is of Hilary on a bicycle with a little attachment to carry the groceries or put the day's. We didn't have laptops in those days. Put the day's working material. That reminds me also pleasure in welcoming her spouse, Dr. Forgive me for sharing on a personal note. Stephanie, Steph, and Will. And Will was extremely and still is very fond of cricket. So when the Indian cricket team went to Australia, she took special permission from the Indian High Commissioner so that little Will could go and meet the Indian cricket team at the reception for which she was invited. And a couple of days later, Hilary spoke to me and said, there's something very interesting that happened. And he just refused to go and brush that night. When I told him as a young child, you have to go and brush and then be done for the day. And he refused to brush. So I asked him, why didn't you brush? So he had met Sachin Tendulkar and shook hands with him. He said, you don't brush and wet your hands after you've spoken to God and shaken hands with God. Well, so much for so much, a few personal things. Last year, to celebrate the legacy of the Supreme Court, we instituted an annual lecture commemorating the momentous occasion sitting on benches January 1950. For the first edition, we were honored to host Justice Sundaresh Menon, the Chief Justice of the Supreme Court of Singapore. This year marks a special year. It is a momentous occasion in the history of the Supreme Court and our nation. The Supreme Court of India has entered the 75th year of its inception. No one better than a judge and a scholar with years of experience and a profound understanding of the law could aptly capture the significance of this milestone. Thank you for graciously accepting our invitation, Justice Charlesworth. At Harvard, Justice Charlesworth worked on her dissertation on constitutional law from the North American and Australian perspective, while I labored over my work on affirmative action in India in the context of comparative law and jurisprudence. As we both toiled over our dissertation, we engaged with the law, but were also compelled to navigate the dichotomous yet intricate relationship between the law and politics. The theme Judge Charlesworth has selected for our lecture today, International Court of Justice, a legal forum in a political environment, is to say the least interesting and topical. It is, of course, of contemporary relevance in view of the unprecedented growth of the docket of contentious cases before the International Court of Justice. Notably, however, the theme for today's lecture also reflects a question that is fundamental to the law and legal systems, both domestic and international. The International Court of Justice held its opening session on 18 April 1946, a time when approximately a third of the world's population, including India, lived under colonial rule or in non-self-governing territories. As the International Court of Justice celebrated 75 years of its inception in 2021, its then President, Joan Donoghue, it is called upon to adjudicate. Today, there are 193 United Nations member states. The existence of a diverse member states community has had a tangible influence on the kind of cases various nations are calling on the court to determine issues of human rights, including questions about the Genocide Convention, as we saw recently, and the Convention on Torture. In this way, the change in global politics has been crucial in shaping the transformation of the ICJ as well. It reflects the deep interplay between politics, power, and the law. Similarly, the institution of the Supreme Court of India in 1950, which we have gathered to commemorate, was also a moment that marked political and social transformation. It cannot be viewed, our founding moment cannot be viewed as divorced from the political realities of its time. The sitting of the Supreme Court for the first time echoed the aspirations of a nascent country, burdened by the legacy of colonial rule and entrenched social stratification, yet equipped with a transformative, progressive, and foresighted constitution. Over the years, the Supreme Court has embodied these aspirations by crafting a vast body of jurisprudence aimed at liberating India from its colonial past and fostering the groundwork for social transformation. In this journey, the apex court of the nation has emerged as a product of the interplay between the polity, societal aspirations, and the law. At this moment, it is important to emphasize that diversity and representation, not only for rectifying historical injustices, but also for enriching the decision making capacity of our courts. The evolving representation of nation states before the ICJ has notably challenged its historically monocultural and Eurocentric outlook. Likewise, integrating gender diversity within the courts would substantially broaden the spectrum of perspectives, leading to more comprehensive and equitable decisions. In her book, Boundaries of the Law, Justice Charlesworth notes that in 1999, when she completed writing the first edition, international law was in a period of renaissance that was marked by the end of the Cold War between the West and the Soviet bloc, the dismantling of the Berlin Wall in 1989, which appeared to have freed international law from its political shackles. The United Nations Security Council had begun to create new institutions and adopt new thematic agendas, such as the protection of civilians and children in armed conflict. Yet, there are times that the new world order, as she tells us, may not necessarily improve the lives of women. And she says widespread violence against civilians, including violence targeting women and girls, accompanied the new wars and ethno nationalisms in, among others, Somalia, Rwanda, Haiti, and the Balkans. The rise in the trafficking in women and girls with opening of borders between Eastern and Western Europe, she says, and the deployment of peacekeeping troops, the increasing prominence of fundamentalist religious groups, commitment to neoliberal economic ordering, and inequalities and violence, accompanying the free market zones, were other signs that patterns of systemic oppression of women and girls would continue in the post-Cold War era. And then the book speaks about feminism, particularly in the context of international law. And she quotes Professor Sandra Friedman, very distinguished professor at Oxford, that what does ultimately feminism mean in the context of constitutional or international jurisprudence? And it means four things. First, the redress of disadvantage, which may require redistributive measures. Second, recognition of the prejudice, stereotyping, and violence that are caused by inequality. The third aspect is ensuring the participation of people in decisions that affect them. And fourth, the achievement of structural or transformative change, which is the fourth dimension of equality. I mentioned these four because we as judges and lawyers are constantly grappling with these ideas, not only in the context of feminist jurisprudence, but in terms of justice to our own marginalized, whether it's the scheduled caste, the scheduled tribes, the other backward classes, and so many other groups in our society. Therefore, from that perspective, I must, at the end, share that the first woman to be elected to the International Court of Justice was named Rosalind Higgins, who was also the first female president of the court. Judge Charlesworth is regarded as one of the pioneers of the feminist approach to international law and has brought this school of thought into the mainstream. She was the fifth woman to serve. She is the fifth woman to serve on the ICJ in the court's 77-year history. Recently, Judge Julia Sebutindi, the first African woman to sit on the ICJ, has been elected as the vice president. To have more women as judges of the ICJ is not the responsibility of the court alone, but a share of the responsibility must be borne by nation states and national groups who are responsible for the nomination process. I dare say the same in regard to the appointment of more women into judicial offices in India as well. I was reading that in October last year, the ICJ amended, among other documents, its rules of courts and practice directions to make their provisions gender inclusive. The Supreme Court of India has also made strides in this regard. The Supreme Court released a sensitization module for the judiciary on the LGBTQIA plus community, which seeks to sensitize members of the judiciary on concepts of gender and sexual diversity, on the usage of appropriate terminologies, and make recommendations of the protocol to be followed by courts while interacting with the members of the queer community. Similarly, the Supreme Court recently released a handbook to combat gender stereotypes in an attempt to ensure that judges use inclusive language and consciously avoid the use of stereotypes in decision making. Before 2024, only 12 women had been bestowed with the title of senior advocate throughout the entire history of the Supreme Court. However, recently, there was a significant shift as the Supreme Court designated an equal number of women hailing from various regions across the country as senior advocates. They will be the torch bearers of change in the future of the legal profession in our society. There was once a notion of law which limited us to merely an isolated arena from society. Today, legal fora across the globe are recognizing that they cannot view themselves as divorced from the socio political realities and aspirations of the time. This recognition fosters an environment conducive to mutual learning and exchange of ideas. I'm hopeful that the lawyers and researchers whom we mentor today, and so many of our law researchers are part of the audience, are going to change the way the legal systems have been working. The new generation of lawyers and scholars are evolving new paradigms to reimagine the conceptions of law and justice. I'm optimistic that the interaction with Judge Charlesworth will not only benefit the Supreme Court of India to learn from and engage with the International Court of Justice in the years ahead, but will inspire the young minds in the audience to reflect on finding solutions to the numerous challenges affecting the globe and our time. I once again extend my gratitude to Judge Charlesworth for gracing the Supreme Court of India with her presence, and I warmly welcome her to India. And now I yield the floor to her for the highly anticipated lecture.
Thank you, sir. Your address was indeed a treasure trove of wisdom, garnered and gathered through experience and wide reading. With this, I request the Honorable Chief Justice, Dr. Justice D.Y. Chandrachud, to present a memento to our esteemed speaker. It is time now to hear our chief guest for the day, Her Excellency, Miss Hilary Charles. myriad forms of discrimination. Through her work, she has challenged the deeply ingrained societal norms and highlighted the urgent need for transformational change by dismantling oppressive structures. Through her work, she has opened places of inclusivity and empowerment. With this, I request our erudite chief guest to kindly address this August gathering who are so eager to hear from her.
Chief Justice, Attorney General, Solicitor General, very distinguished former and present judges of the Supreme Court and of judges from across India, dear guests, dear colleagues, dear students, dear friends. Ma Puhut Ni Kushi Kush Yad Muhe Yaha Mahap Ya Saye. It's indeed a really great honor to have been invited to deliver this second lecture to celebrate, to mark the anniversary of the foundation of the Supreme Court of India. And I'm very conscious that this is the launch of the 75th anniversary year. And I'm very, very grateful to the Chief Justice, Dhananjay Chandrachud, for the invitation. As he's already told you, we met 40 years ago as students at Harvard Law School, and I still recall us nervously sitting together in Professor Tribe's course on American constitutional law, and we were both terrified that he would call on us impromptu, and this was a very bonding experience, but we spent these wonderful years at Harvard together exploring all the richness of that wonderful institution. So you will not be surprised that the Chief Justice stood out even then as an absolutely brilliant, but also for me, more important, a very generous person. And allow me to say that my family and I have deeply valued our friendship with him and his family over the years, and we hope it will continue to the next generations. Allow me also at the start to thank the staff of the court and the registry for great making all the arrangements for my visit. As you can tell, perhaps I've long had a fascination with India after studying Indian art and history at university. And then as a student, as you've heard, I did spend a year teaching, it would be perhaps a bit shocked to hear, geography and hockey, of all things, at Mayo College in Ajmer. But exploring India that first year, that was my first visit, and I was here that year and had a chance to travel a lot, was really a profoundly life-changing experience for me. And I visited a number of times since. And I have to say, it's just wonderful to be back here in this vibrant country. I have been wondering since I received this invitation what thoughts I can offer this very distinguished audience. And I did have the good fortune of reading last year's speech by the Chief Justice of Singapore and noting that he was able to draw on his long experience to distill lessons for fellow members of the judiciary. So I hope, given that I can't give you many lessons from my long career as a judge, that instead it might be of interest if I gave you a picture of the world of international judicial institutions, particularly focusing on the one that I joined just 2 years ago. I know, of course, that over the years, the Supreme Court of India has manifested an interest in the work of the International Court of Justice. Unlike many other constitutions, the Indian Constitution acknowledges the role of international law in Article 51, part of the Directive Principles of State Policy. And the Supreme Court of India has, of course, regularly referred to international law and indeed on occasions to decisions of the International Court of Justice. Indeed, I've been struck that it appears much more open to invoking international law than other apex courts, such as my own, the High Court of Australia or the United States Supreme Court. But what I would like to do today is to start with describing the history and structure of the International Court of Justice. And then I want to discuss how it navigates its role as a legal institution in deeply divided political environments, that implicate questions of judicial independence. Of course, the International Court of Justice's structure and jurisdiction are quite different to those of the National Court, such as the Supreme Court of India, but I hope that you will find nevertheless that some of our experiences resonate with you. Well, the origins of the court, and this is our modern court building today, uh, date back to the early part of the 20th century. And you can see here an image of the Hague Peace Conference, of the participants at the Hague Peace Conference of 1899, gathered on the steps of what's now the royal residence, the House ten Bosch, just outside The Hague. So there were two Hague Peace Conferences, 1899 and 1907, both strikingly initiated by Tsar Nicholas II of Russia. And those two conferences together resulted in the establishment of an institutional structure of the international arbitration. And this is the Permanent Court of Arbitration, which is still going strong today. But an arbitral court is not a judicial institution. And there were moves in the early 20th century to create an international judicial tribunal. But these ideas only came to fruition after the First World War. And indeed, the Covenant of the League of Nations of 1919 precisely envisaged the establishment of what was called the Permanent Court of International Justice. And this permanent court was housed in the same building, the Peace Palace, or in The Hague. And I've got, this is a picture here of the inauguration of that building. And perhaps in the front with the white beard, you can see the founder of the Peace Palace, the Scottish-American philanthropist Andrew Carnegie, on the opening day. So the first occupant was the Permanent Court of Arbitration, but it was then forced to provide half of the building for the Permanent Court of International Justice. So the Permanent Court was inaugurated in 1922, and indeed in that year it dealt with 3 requests for advisory opinions that had come from the Council of the League of Nations. In its life, between 1923 and 1940, the Permanent Court delivered judgments in 29 cases between states, and it rendered 27 advisory opinions. And its last public sitting was in 1939, just after the outbreak of the Second World War. And this is an image of formally the last meeting of the Permanent Court of International Justice, which took place because of the war. Because at that time, of course, the Netherlands was occupied. This is the image of the court, as it were, disbanding itself in 1945. I should say some of those judges immediately became judges of the successor court, the International Court of Justice. So the new court, the International Court of Justice, which was established under the Charter of the United Nations, and we inherited a statute almost identical to that of the Permanent Court and adopted remarkably similar rules of procedure. And even today, our court operates under rules of procedure, many of which were first devised in 1922. The International Court, however, distinct from the Permanent Court of International Justice, was elevated to the status of a principal organ of the United Nations, institutionally on the same level as the UN Security Council and the General Assembly. Well, as for our structure, that is, I should say, this is the opening of the International Court of Justice, the first hearing, and perhaps in the front row of the audience, you can see the then young Crown Princess Juliana of the Netherlands, who went on to be, of course, a long-standing Queen of the Netherlands. You can see the inaugural judges gathered round the table there. Well, this is the latest, what we call the family photo. I should say that the court, we had a new composition starting just on Tuesday. So this is the court in its composition as of last Monday. But as of Tuesday, of course, we lost 4 of our colleagues, including our president, Judge Joe Donoghue, and our vice president, Judge Kirill Gavorgin. But this shows you the one photo I could find of all the judges, all the old composition of the court together. So the court is composed of 15 judges who are required to be of different nationalities. And judges are elected by the United Nations General Assembly and the United Nations Security Council, voting simultaneously. And judges are elected for 9-year terms, which are renewable. The court statute, and I quote from it, mandates representation of the main forms of civilization and the principal legal systems of the world in the court as a whole. And how that's translated in practice is that requirement is observed in an informal regional allocation of the 15 seats. There has also been a tradition that the 5 permanent members of the Security Council always have a national on the court. This was so until 6 years ago, when the United Kingdom famously, I think I don't need to remind the Indians, lost its seat on the court. And in the most recent judicial elections in November last year, Russia, as it were, lost its seat on the court. So there are three permanent members of the Security Council still have judges on the court. So we can't really refer to that as a long-standing tradition anymore. The statute doesn't refer to gender representation, unlike, for example, the Rome Statute of the International Criminal Court. And I think overall, the International Court of Justice has a poor record in attention to gender balance. In almost 8 decades, just 6 women have been elected to the court, while 109 men have been elected at the same time. Today, with our President Joe Donahue has been the new American judge, Professor Sarah Cleveland, has joined us. So we are still 4 women and 11 men. You will be aware that a former member of the Supreme Court of India, Judge Dalbir Bhandari, we call him judge at the court. I'm aware that he would be justice here, but Judge Bhandari at the moment is a current member of the court. Other distinguished judges from India include B.N. Rao, one of the architects, I need not tell you, of the Indian Constitution. He was elected to the court in late 1951, but sadly died before he even completed 2 years in office. Perhaps the longest serving Indian jurist that we've had on the court is Judge Nagendra Singh, who sat on the court for 15 years in the 1970s and 80s. And he also served as the court's vice president and then president. And as president, he presided over perhaps one of the most significant cases in the court's history, the Nicaragua case. And I'll come back to that case. Every day I walk past this statue of Nagendra Singh, Judge Nagendra Singh, because if you're president at the court, you are allowed to choose either a sculpture or a portrait. And so the sculptures are displayed in the judge's wing. So I feel, although of course I never knew him, I feel I see Judge Nagendra Singh every day with this splendid bronze portrait. Another Indian judge on the court, Raghunandan Swarup Pata, who was appointed when he was elected to the court when he was Chief Justice of the Supreme Court. And he finished Nagendra Singh after Nagendra Singh's death in 1988. The court invariably sits with all of its 15 members. The statute of the court, it's true, contemplates the formation of specialist chambers to hear particular cases, but that course has, surprising to me, it's been very, very rarely invoked. It's at the discretion of parties to call on the court to constitute a smaller bench. So almost invariably, we sit in the composition of all 15 judges. If there's no judge of the nationality of a state party to a dispute on the bench, that state may appoint a judge ad hoc for that case. So in some cases, we have 16 or even 17 judges. In 3 out of the 6 cases involving India during the court's 8 decades, there was no Indian judge already on the bench. And so various distinguished Indian jurists were appointed as judges ad hoc. So one was the former Chief Justice of the Bombay High Court, N.C. Chagla, who was ad hoc judge in the Rights of Passage case, the case brought by Portugal against India in the late 1950s. Judge Nagendra Singh, he was also, before his election to the bench, he served as judge ad hoc in a case India brought against Pakistan relating to the jurisdiction of the ICAO Council. And Supreme Court Justice B.P. Jeevan Reddy was appointed ad hoc judge in a case that Pakistan brought against India, the aerial incident of the 10th of August 1999. So that's the membership of the court. What about jurisdiction? In its contentious jurisdiction, the court deals only with disputes between states. So unlike the International Criminal Court, uh, we never see individuals as such in the court. They are never before us as individuals in the court. All 193 members of the United Nations are automatically parties to the court statute, but that doesn't necessarily mean that they accept the court's jurisdiction. There was some discussion whether the court should have compulsory jurisdiction during the drafting of the UN Charter at the San Francisco Conference in 1945. And that position, the court having compulsory jurisdiction, was certainly championed by smaller states such as Australia and New Zealand. But ultimately, the view of the United States, the Soviet Union, and the United Kingdom prevailed, and that was that jurisdiction should be voluntary, and that's the situation today. So there are three distinct ways by which cases can come before the court. First of all, it's possible for states to enter into a special agreement to submit a dispute to the court. We have a nice example of one such case currently on our docket, and this is where the Caribbean coast neighbours of Guatemala and Belize have agreed to submit a territorial dispute to the court. So that's one route, and that's in fact the easiest route because one knows there will be no challenges to jurisdiction or admissibility. But a second route is when both states are parties to a treaty that grants the court jurisdiction to decide disputes between treaty parties. And examples of such treaties that have such a jurisdictional clause include the Genocide Convention. And of course, it was precisely Article 9 of the Genocide Convention that was invoked by South Africa in its recent case against Israel. There is the Convention on the Elimination of Racial Discrimination that also has a jurisdictional clause. The Convention on the Elimination of All Forms of Discrimination against Women, and the Convention against Torture. So the court at the moment has a number of cases that are based on such clauses. There are two brought against Russia by Ukraine on the basis of a range of different treaties. There's a well-known case that the Gambia has brought against Myanmar on the basis of the Genocide Convention. There are cases between Armenia and Azerbaijan. Each country has got cases against each other based on the Racial Discrimination Convention. And a case brought by Canada and the Netherlands against Syria based on the Convention Against Torture. So that's the second method, jurisdictional clauses in treaties. But a third method by which states manifest consent is by making a standing declaration accepting the compulsory jurisdiction of the court. So just over a third of the 193 members of the United Nations have done this. And Australia, my country of nationality, has, and India, of course, also has accepted the court's compulsory jurisdiction right since the inception of the court. I do note, however, that no other member of the BRICS grouping has done so. And strikingly, only one of the permanent members of the Security Council, the United Kingdom, has such a declaration in force. The most recent declaration comes from Canada in August 2023. Many of these declarations, however, are accompanied by broad reservations which constrain the court's jurisdiction. So to give you an example, Australia's current declaration excludes inter alia all maritime delimitation disputes. And for its part, the Indian Declaration, which was revised in 2019, excludes 11 categories of dispute, including disputes with states that are or have been members of the Commonwealth, and also, and I'm quoting, disputes in regard to matters which were essentially within the domestic jurisprudence of the Republic of India. Like the Permanent Court of International Justice, the International Court also has an advisory jurisdiction whereby certain UN organs can request advice, and the critical words in the Charter are on any legal question. And this image is an image of the Chagos Archipelago, and this represents the most recent advisory opinion rendered by the court on the status of the Chagos Archipelago in 2018. I found in the archives, this is another, it's a historic photo, but it shows Judge Nagendra Singh sitting as so you can see the registrar sitting at the right of the bench, and then Judge Singh is two judges in. But this is an image of the International Court hearing the court's arguments in the very famous advisory opinion case on the Western Sahara in 1971. In its 78 years then, the International Court has considered 182 contentious cases and delivered 27 advisory opinions. What of enforcement? Unlike international, some other international or some domestic courts, the International Court of Justice is not involved in the implementation or the enforcement of its decisions, even its binding judgments. So once the court delivers its judgments, the court's work is considered done. So the enforcement of the court's decisions falls on states themselves, first and foremost, the states parties to the case. The United Nations Charter includes an undertaking by all UN members, and I quote here from Article 94, an undertaking to comply with the decision of the International Court of Justice in any case to which it is a party. And Article 94 goes on to provide that a party to a case who's dissatisfied with another party's performance of its obligations under a judgment can have recourse to the Security Council. And the Security Council, under the same article, is given the power, and I quote from it, to make recommendations or decide upon measures to be taken to give effect to the judgment. However, what's striking we're looking now at 8 decades, the Security Council has never exercised those powers that it has. Now, how can we explain this? Of course, the use of the veto by one of the 5 permanent members of the Security Council can really effectively stymie that route of enforcement. Indeed, in one case, the United States used its veto power to block any action by the Security Council which respects the enforcement of judgment against it. This was the case that you'll hear me refer to a few times, the case between the United States and Nicaragua. In the end, the implementation of that judgment, which was delivered in 1986, really was resolved by a broader negotiations package many years later between the 2 states. So the means and modalities for compliance can vary and depend on the nature of the case, and they can involve the assistance of regional organizations, including. So one example of this is the implementation of the court's decision in an interesting case which resolved a dispute, a land and maritime boundary dispute between Cameroon and Nigeria. So the court gave its decision in 2002, and then there was a lot of dispute between the 2 countries because there were many resource issues riding on this about how actually to implement the court's judgment. And the Secretary General recommended, using his good officer's function, recommended that the 2 states establish a commission for the implementation of the judgment. And this commission, and here is an example of the commission in action looking at a boundary marker. This is from the commission's own website. And this commission, which is made up of experts from both of the 2 countries, is chaired by a special representative of the Secretary General, and it also has several of its own subcommissions and working groups. And each year, the Secretary General makes a report to the Security Council on the Commission's progress. So it's on the Secretary General, the Security Council's agenda every year. But it is slowly, if one follows the reports, we can see it's slowly, the judgment is slowly being implemented, with the emphasis perhaps on the word slow, but at least it's being implemented peacefully. Other judgments are more straightforward and states are generally willing to implement them. I think no state welcomes being found to have acted in violation of international law. For example, almost 2 years ago to the day, the court awarded 325 million United States dollars compensation in favor of the Democratic Republic of the Congo for damages caused by Uganda in the context of an armed conflict that involved significant violations of human rights law and the laws of war at the turn of our most recent century. But it's at least reported in the press that Uganda has been complying with the judgment by paying the compensation due in instalments as proposed by the court. So it seems that despite the limited apparatus of enforcement of the court's decisions, they nevertheless often have considerable influence on state behaviour. In many ways, the legitimacy of the court's pronouncements depend on the confidence of the members of its international constituencies, states and international organisations. the confidence they have in it, which in turn turns on the persuasive force of its reasoning. I must acknowledge that there have been some very lean periods in the court's life. And the longest lean period, I think, perhaps was the period after the delivery of the judgment in the Southwest Africa case in 1966. And this is an image of the case being argued before the court. The court, after it heard the hearing, it had 16 judges in that case. There was an ad hoc judge. The court was evenly divided on the question whether Ethiopia and Liberia, two African members of the League of Nations, did those two states have standing to challenge South Africa's performance of its duties as mandatory power over Southwest Africa or modern-day Namibia. Those two states, Ethiopia and Liberia, argue that South Africa's extension of its policy of apartheid to Southwest Africa was inconsistent with the terms of the League of Nations mandate over the territory. So because there were 16 judges and the vote was 8-8, so the vote was split, and under our rules of court, the president of the court, who's represented here, in fact, this is the Percy Spender, the first Australian elected to the court and the only Australian president of the court. Here he is announcing the court's decision, and he cast his casting vote against Ethiopia and Liberia's standing. Many of the new members of the United Nations from the developing world were dismayed by this decision and lost trust in the court as a useful forum for dispute resolution. That distrust was deep and it lingered for 20 years, really until the court's 1986 decision in Nicaragua against the United States. And that, the Nicaragua case, as I mentioned, was actually decided under the presidency of Judge Nagendra Singh. Today, despite that low point in the court's history in the 20 years when there was barely a case on the court's docket and some judges found themselves becoming elected to the court and simply never hearing a case on the court because there was such loss of faith in the court. But we are at one of the busiest points ever. After just speaking beforehand to the Chief Justice, I'm embarrassed to tell you about the size of our docket after hearing about the size of the docket of the Supreme Court. But this is the biggest docket ever. We have 18 contentious cases from every region of the globe. The cases range from land and maritime boundary disputes to, as I've mentioned, allegations of race discrimination and genocide. We received last year 2 requests for advisory opinions from the United Nations General Assembly, one on the legal consequences of Israel's policies and practices in the occupied Palestinian territory, and we're just about to begin hearing. In September, the International Labour Organization requested from the court an urgent advisory opinion over the years. One standard criticism that I'll take on now is that international law operates in an intensely political context and that its principles are more the product of politics than true law. On this argument, international judges are often taken out of the purely legal realm and they're called on to make political decisions. This criticism isn't peculiar, of course, to international law. In several domestic jurisdictions, including Australia, it's sometimes argued that the courts, especially the appellate courts, should keep at arm's length the category of questions that are incapable of legal decision, questions that are deemed non-justiciable. Then, as now, international adjudication has always been premised on the consent of sovereign states. agreeing to submit their disputes to a third-party arbiter. So the argument in international law runs that some disputes are politically sensitive, and the disputes touching on the vital interests, or sometimes it's called the honour of the state, are simply too important to be left in the hands of international judges. So the idea is that the role for courts such as the International Court, that they should simply occupy themselves with technical cases such as land and maritime boundary disputes. But what's technical and what's an issue of policy? The inherently subjective, if not self-judging character of that sort of argument is evident. But beyond that, the argument rests on a purported distinction between the realm of politics and the realm of law. Politics and law are not different provinces of social organisation. Rather, I see them as different lenses through which to observe social experience. And so every relationship, including every conflict between states, can be approached through a legal perspective, much as every relationship and conflict between individuals can. As with relationships between individuals, it may be more or less useful to approach a given relationship between states through a legal lens. But that doesn't make it impossible, nor inevitably futile. Of course, this isn't to say that law can provide the only angle on relationship or a conflict. Being one of multiple lenses, law will hardly ever offer a perfect image, but it provides an important thread in a fabric of regulation that can be woven with threads of politics, economy, history, public opinion, and culture to influence behaviour. In its practice, the International Court has affirmed that it may, indeed it must, decide the legal aspects of disputes that are properly submitted to it. And it has held that any dispute framed in legal terms is essentially a legal dispute. The court articulated that idea unequivocally for the first time in a case arising in the wake of the Iranian Revolution of 1979 and in the siege of the US Embassy in Tehran. So, with its nationals still taken hostage, the United States resorted to the court, complaining that Iran was breaching the inviolability of diplomatic premises and the immunity of diplomatic and consular staff. Iran responded in turn that this act should be seen against the United States' decade-long interventionist policy in Iran's domestic affairs. So even though the relations between the two states were extremely tense, the court did not shy away from this dispute, and it held that its constitutive instruments did not contemplate, and I quote from the court's judgment, decline to take cognizance of one aspect of the dispute merely because that dispute has other aspects, however important. End quote. Of course, sometimes that decision has been explained as simply a political move by a Western-leaning court, then presided over by a British judge. After all, it said this was the same court that had fairly recently decided not to grant Ethiopia and Liberia standing in the Southwest Africa case. Yet, it was not long after the case by the United States against Iran that the court applied exactly the same principle against the United States itself. The Caribbean country, the Central American country of Nicaragua, fought a case in 1984 against the United States, complaining about its interventionist policies, its funding of religious in that country. And the United States, when it was brought by the court before it, the United States made the argument that the court should not rule on this case. It's a case that's susceptible only to political resolution. It's one that's not susceptible to legal resolution. And indeed, the United States is counterproductive to the political resolution of the dispute between the parties if the court gave an opinion in the matter. Well, the court gave very short shrift to the United States argument, acting consistently with its decision. And here is Judge Nagendra Singh presiding in that case. And the court said that its role was to decide legal questions, even if they form part of a broader political dispute. In 2017, India found itself in a situation comparable to that of the United States in its case against Iran, or Nicaragua in its case against the United States. Kulbhushan Sudhir Jadhav, an Indian national, had been sentenced to death by a Pakistani military court on counts of espionage and terrorism. So here is a picture of the Indian team in the Great Hall of Justice. And India relied on the same convention that the United States had in its case against Iran, the Vienna Convention on Consular Relations. Um, and India claimed that Mr. Jadhav was denied his right to consular assistance by its state of nationality. And the court certainly agreed with that argument. Now, of course, it's obvious that the court's judgment didn't resolve all tensions between India and Pakistan, but at least it provided a resolution, a legal resolution to an acute problem dividing them. So let me then move on to independence of judges. The political context in which the International Court of Justice inevitably operates, because we're the United Nations primary judicial body, this gives rise to a second form of criticism that relates to the independence of judges. Popular commentary on the court, and here you can see this is a photo actually of the court taken just last Monday as we were swearing, our new colleagues were making their declarations, their solemn declarations, and temporarily the president of the court was the most senior judge on the court, Peter Tomper, who is in his third term on the court. Judge Tomper is from Slovakia. So that's the court as let's say in its new composition. But there's a lot of commentary on the court that often presents it, especially in the popular media, as an almost entirely political organ, whose members effectively represent the interests of their states of nationality. The nationally and legally heterogeneous backgrounds of the judges are assumed to make judicial consensus unlikely. And in this respect, many commentators contrast the ICJ unfavourably with national courts, which are taken to represent the acme of the judicial function. On this analysis, the International Court has at best the caricature of court, offering, however, a highly restricted form of judicial independence. So I cite as an example the American academic Eric Posner, writing in 2006, and he concluded in a famous article on the topic that the International Court of Justice was basically lost because it could neither please the major powers, which resisted any constraint on their actions, nor could it maintain the loyalty of smaller powers, which in his words regarded the court as a puppet of the major powers. Well, Eric Posner and other scholars have studied the voting behaviour of international judges, focusing on the extent of their independence from the state that nominated them, and drawing very pessimistic conclusions, basically saying judges will always vote in favour of the interests of the state of their state of nationality. The decision in the Nicaragua case in 1986 is very interesting in the literature. As soon as that case appeared, there was a flurry of claims by mainly United States lawyers, academics, that the members of the International Court weren't independent. And promptly, before the court went on to hear the merits of the Nicaragua case, the United States withdrew its statement of jurisdiction. So, and it said, well, the reason why the United States has done so is because the court essentially is not composed of independent judges. Such scholars have gone on to explain the reluctance of some states to appear before the court as based on a lack of trust in an international judiciary to apply the law impartially, assuming always that the judge is going to vote in favour of positions that promote the interests of their home states or that reflect their own cultural prejudices. So the question of judicial independence is one that confronts all courts and is vital to their legitimacy. It is of acute importance in a global era of democratic decay and growing autocracy. And I was very struck by the fact that Chief Justice Chandrachud emphasised the centrality of judicial independence in his wonderful address that he gave at the ceremonial sitting of the court just 2 weeks ago. But what does judicial independence mean in an international context? And what I struck in preparing for this talk is how little reflection there is on this question in the scholarly literature. So students of international law, this would be a wonderful question for a PhD thesis. The court statute describes the court, and I quote, as a body of independent judges elected regardless of their nationality from among persons of high moral character and legal competence. And the new judges, and you can see them actually standing to make their solemn declarations in this photo, um, the solemn declaration is one to perform their duties and exercise their powers as judge. The four words are honourably, faithfully, impartially, and conscientiously. And so there are several provisions in the court's institutional framework that seek to preserve the impartiality of judges, that is, the absence of bias in favour of one party. So, for example, the court statute forbids judges to participate in cases in which they've previously been involved in a different capacity, such as counsel for one of the parties. On occasion, this principle has been applied very rigorously. For example, B.N. Rao, the distinguished uh, Indian jurist who I mentioned earlier, was the Indian ambassador in the Security Council at the time it was called on by the United Kingdom to consider whether Iran was failing to comply with an interim injunction or a provisional measure that the court had issued in a pending case between the UK and Iraq. When B.N. Rao then was elected to the court shortly afterwards in 1951, he decided himself that he should not participate in the court's deliberations in subsequent phases of the case between the two countries. So he clearly had a very high standard there of impartiality. But I see independence as different from impartiality. It's aimed at eliminating not any preconception that judges may have, which I take to be impartiality, but rather any non-legal considerations that might affect a judge's review and cloud their judgment. Independence and freedom from any sort of extra legal pressure is a trait to be ensured not only by each judge individually, but also by the judicial institution as a collective. At the same time, of course, guarantees of independence must not shield judges from accountability. And that's often a fine balance. In this regard, we can see in the International Court of Justice's basic documents rules that are frequently found in domestic and international judiciaries. The incompatibility of a judicial function with any other profession, notably political or administrative functions, the impossibility of removing a judge, say by unanimous decision of the court itself, and judicial immunity. The value of other rules and practices in safeguarding judicial independence is less obvious, and it may sometimes depend on a domestic legal heritage. On this point, an international institution such as the International Court of Justice brings to the fore various and potentially diverging, indeed clashing conceptions of independence, and it tries to accommodate them. Take, for example, the rule concerning the secrecy of deliberations and voting. It's fairly uncontroversial in most systems that judicial deliberation should be secret. But what about voting? Our court, the International Court statute, is silent. To a common lawyer, it may seem obvious that the judgment could indeed should indicate the way in which each individual judge voted in the operative clause of the court's decision. The fact that the International Court statute explicitly gives judges the right to append individual opinions seems to point in the same direction. But on the other hand, it's been argued, especially by those from a civil law tradition, that to identify the individual judge's votes not only undermines the authority of the judgment, but that it also exposes those judges to real or perceived pressure to vote in a particular way. For more than 50 years, the practice of the ICJ and its predecessor was not to indicate the way in which each judge voted. And it was only in 1978 that the court amended its law so that now its decision could also indicate the names of the judges constituting the majority. All of these guarantees may indeed protect a judge from immediate attempts at manipulating her. But there are, of course, more subtle forms of influence. For example, there are no limits to re-election at the International Court of Justice. So a judge who's facing re-election in the near future may theoretically be tempted to modify their views to align them with influential elected states. For that reason, several judges, including the recently retired President of the Court, Joe Donoghue, have proposed a single non-renewable term for International Court of Justice judges. She suggested in her recent address to the Sixth Committee of the General Assembly, perhaps there could be a single term of perhaps 12 rather than 9 years. Non-renewable terms are already the rule in various other international courts, and they've been recommended by the Institute of International Law, the oldest learned society of international law. Such reform would, of course, require amendment of the court statute, which is not in the hands of the court itself. Nonetheless, the court has adopted a series of decisions as well as some informal practices that set limits to the invitations or decorations that judges may receive and to their participation in external activities, in arbitrations, and so on. Uh, to conclude then, assertions of lack of independence are regularly made about judges who staff international judicial institutions such as the International Court of Justice. Almost all disputes and requests that arrive at the court have a clear political context, and some observers are keen to question the court's ability to resolve such issues on the basis of law. And yet, in my view, I think the court has largely, overall, managed to adjudicate the legal aspects of politically sensitive disputes with integrity. Judicial independence is critical to the operation of legal institutions, particularly in volatile political contexts such as the international sphere. But its content is not easy to pin down. At the international level, where a diversity of judicial backgrounds is vital, judicial independence, the idea of judicial independence, must accommodate intellectual, social, cultural, and national differences. I think it's important to develop more sophisticated accounts of judicial independence than simply tracking vote patterns, with all due respect to those who engage in that research. The United Nations Special Rapporteur on the Independence of Judges and Lawyers has recently identified some current challenges to judicial independence in national legal systems that I think apply also to the international level. These challenges include disinformation that's spread online, online harassment and threats, and also the misuse of artificial intelligence. The Special Rapporteur also emphasises the composition of the judiciary as a critical element of judicial independence, noting, these are the words, the importance of participation in the judiciary articulated for those who commonly experience discrimination, including women, members of minority groups marginalised, for example, because of their ethnicity, race, or sexuality, or persons with disabilities. I think judicial independence is a field where the international judiciary, of which I'm a member, has much to learn from the practice of national courts. Our two courts, the Supreme Court of India and the International Court of Justice, while very different, I note that we're of a very similar age. You're going into your 75th year, we're going into our 78th year. We're slightly older there, you're older there. But we both face the task of navigating highly charged political environments as legal institutions. The international judiciary, I think, can draw inspiration from the Supreme Court of India's distinguished history of independence and innovation. What is also really impressive to me is the Supreme Court's courageous capacity of introspection, which, to quote the Chief Justice's recent talk at the ceremonial sitting, and I quote from him, introspection is the art of bringing the seemingly unattainable within the line of vision. This, it seems to me, is a vital quality of introspection for true judicial independence. Chief Justice, let me congratulate the Supreme Court on its Foundation Day, on its anniversary year, and I wish it a rich and rewarding future. Aap sabhi ka bahut dhanyavad.
Thank you so much, Your Excellency. Your words are a reminder that through judicial independence, we can bend the arc of history towards a more inclusive and equitable future. We owe a debt of gratitude to